You guys, and welcome to the Legal Table. I am your host, Crystal Jamerson, and I'm the Community Engagement and Outreach Coordinator for Legal Services of Northwest Minnesota. The Legal Table was created to educate you on your rights, responsibilities, along with kind of introduce you to community organizations that have resources to help you along the way. Today, I'm so excited. We are going to be speaking about protective orders in Minnesota. So protective orders, they're super important because they give people facing harassment or domestic violence a way to protect themselves. These orders help individuals stand up for their rights and keep themselves and their loved ones safe. They make sure that everyone has the option to take legal action, and when they feel unsafe, creating a community where they can feel more secure and supported. So presently, we're trying to make sure that people in the counties that we serve are aware of their options and the resources available for its community members. And as you know, Legal Services of Northwest Minnesota, we serve 22 counties. We have 3 offices, and we assist clients in navigating the justice system. And we provide low-income individuals with their civil legal needs. Um, Outside of full representation for a client, we have legal kiosks in 87 locations in our service area, and they provide assistance with virtual courts and legal documents. We have a justice bus, which is our mobile clinic, and it allows us to go into the communities where transportation is limited to provide legal assistance. We also have self-help clinics, which we have our new virtual self-help clinic. So if you do have somebody that's in a rural area, we're able to help with the do-it-yourself type court forms. So all in all, we hope to bring you some more information on many civil legal topics throughout the year. So make sure you continue to join us and pass the information along to your coworkers and clients. The nice new thing that we have going on right now is all of our courses that we have qualify for a one standard CLE credit. So we are submitting all that information. So if you joined us today, you should get an email and let you know as soon as that credit has been approved. We'll send you the little code so that you can go ahead and take care of that. So excited to bring that to you today for free. With that being said, I wanted to introduce our guest today. We have Sammy Sexton from Standpoint, and then we also have Sarah Matthews from Red River Children's Advocacy Center. Sorry. And Kim Anderson Moan from Someplace Safe. So welcome, ladies, to our table today. We're going to do some little chats. Real quick, just a few house rules. Please make sure to put all of the questions that you have in the chat, and we'll get to them at the end of the presentation. Okay, so even if it's for a specific presenter, we'll do them at the end. But you can feel free to put them in the chat so you don't forget what they are. Also, this is a quick hour-long meeting, so if you would like more information, each panelist will have their information listed at the end of the meeting along with their logo, so you kind of know which one to follow on the social media platforms. This meeting will be available on our YouTube channel by the end of the week. So if you have any coworkers that were unable to make it, please make sure to check out our channel. And all of our previous legal tables, they're on our YouTube channel as well. So you can always share that channel information. And then, so I think I covered everything. If you do have questions, like I said, I'll be kind of following the chat so I can help out and then be able to get the information to the presenters. Without further ado, we are going to go ahead and turn the mic over to Sammy. And Sammy, if you can introduce yourself and let us know why you're here today.
Yeah, thank you. So my name is Sammy Sexton. I'm a staff attorney at Standpoint, and we provide services statewide for victims, advocates, and attorneys. We have an action line that anyone can call with questions about their cases. And we have advocates who answer our action line, and then also attorneys like myself who can provide legal advice when the situation is appropriate for that. And I am here to talk about the different types of protective orders that are available. So we're going to talk about orders for protection, harassment restraining orders, and domestic abuse no contact orders. And I just have a few slides that I'll share to help kind of illustrate some of the differences. So the first type of difference between these orders is where they are found in Minnesota statutes and what type of court they come from. So, in order for protection, the authority for that comes from Minnesota Statute 518B.01, and those orders are issued by family court. A harassment restraining order, the authority comes from Minnesota Statute 609.748, and those are civil orders. A domestic abuse no contact order is in Minnesota Statute 629.75, and those orders come from criminal courts. There's also differences in what types of behavior qualify for different types of orders. So for an order for protection, the petitioner has to allege that there has been physical harm, bodily injury, or assault, the infliction of fear of imminent physical harm, bodily injury, or assault, terroristic threats, which are also called threats of violence, criminal sexual conduct, sexual extortion, or interference with an emergency call. For a harassment restraining order, the petitioner has to allege that there's been a single incident of physical or sexual assault, repeated incidents of intrusive or unwanted acts, words, or gestures that have a substantial adverse effect or are intended to have a substantial adverse effect on the safety, security, or privacy of another, a single incident of non-consensual dissemination of private sexual images, a single incident of using another's personal information without consent to invite, encourage, or solicit a third party to engage in a sexual act with them, targeted residential picketing, or a pattern of attending public events after being notified that their presence at the event is harassing. For a domestic abuse no contact order, these come up in criminal cases, so they are not a separate case. So that these come up when there are criminal charges pending or a conviction for domestic abuse, harassment, or stalking when that is committed against a family or household member, violation of an order for protection, or violation of a prior domestic abuse no contact order. There's also a relationship requirement for some of these orders. For a harassment restraining order, there is no special relationship necessary, so anyone can file for a harassment restraining order against anyone who has harassed them. For an order for protection, that can only be filed against a family or household member, which is defined in the statute. It includes people related by blood, parents and children, two people who are married, people who have a child together, people who live together or previously lived together, and people who are in a significant romantic or sexual relationship. And that's the same definition that gets used in the context of a domestic abuse no contact order as well, because those underlying criminal charges usually require that there is that same family or household member relationship. There's also differences in the type of relief that can be ordered in each of these types of cases. So an order for protection is the broadest. It can include a standard no contact provision, but it can also include things like temporary possession of property or temporary custody, child support, spousal maintenance. It can order restitution for expenses incurred as a result of the abuse. It can exclude the respondent from the petitioner's home, their work, their daycare, and it does include a shared home. So if the petitioner and respondent are living together, the order for protection can still exclude the respondent from that shared home. And an order for protection can also have a firearm restriction if the order is issued after a hearing. A harassment restraining order is much more narrow, so it can only have a no contact provision and a provision for no harassment. So if the harassment is being done by something other than direct contact, the court can order the respondent to stop that harassment. Otherwise, that's pretty much the only relief that can be issued. And if the petitioner and respondent in a harassment restraining order live together, the court cannot exclude the respondent from that shared home. So that's a pretty big difference between the order for protection and harassment restraining order. The harassment restraining order also does not have a firearm restriction. There's nothing in the statute authorizing that, and so the judge is not allowed to prohibit the respondent from owning firearms. For a domestic abuse no contact order, this is also pretty narrow. It can only prohibit contact between the two parties. Technically, the statute doesn't say explicitly that the defendant can be excluded from a shared home if the victim lives with them. But in practice, I've seen orders that do that. So it does happen. But that is the only relief that can be included in the domestic abuse no contact order is just no contact and don't go to their home. The domestic abuse no contact order does not have its own firearm restriction, but a lot of criminal cases have consequences for firearm ownership. So there might be other provisions that apply. So, for example, if someone is convicted of domestic assault, there are firearm restrictions that go with that. There's restrictions if someone is convicted of a felony or of a crime of violence. There's also a federal law that prohibits someone from owning firearms if they are convicted of a domestic violence crime. So even though the domestic abuse no contact order doesn't explicitly have the firearm restriction, if they are convicted of certain crimes, there's going to be a restriction anyway. And as far as fees go, for an order for protection, there is no fee for the petitioner or for the respondent if they file anything in response. There's no fee for them either. For a harassment restraining order, in a lot of cases, there will be no fee, but not all of them. So if if the petition is alleging any criminal harassment or stalking or criminal sexual conduct, then the fee is automatically waived. If the fee is not automatically waived, then the petitioner can still apply for a fee waiver based on their income, just like they could in any other type of case. But if the court doesn't waive the fee, then they do have to pay a filing fee. And a domestic abuse no contact order doesn't have any fee associated with that, although it is sought by the prosecutor. So it's not the victim filing for a domestic abuse no contact order, it is the prosecutor in the context of that criminal case. For the order for protection or the harassment restraining order, that is going to be filed by the victim. There are really strict hearing timelines as well for an order for protection. If there is an ex parte order issued, the court is required to hold a hearing within 7 days. If there's no ex parte order issued, the court has to hold the hearing within 14 days. And if there's an ex parte order issued, but there's no hearing required because the petitioner only requested limited relief, but then the respondent later requests a hearing, the court has to hold that hearing within 10 days of receiving the respondent's request. For harassment restraining order, there are no timelines for hearings, so it's just whenever the court has time on their calendar, and that sometimes means that you're waiting for months for a harassment restraining order hearing. For a domestic abuse no contact order, these are addressed in any proceeding in which pretrial release or sentencing issues are decided. So it's just going to go along with the timeline of the criminal case. And then just some additional notes about these types of orders. Just because one is dismissed, there might still be another one in place. So sometimes there's an order for protection and a DANCO in place, and the petitioner might agree to dismiss the order for protection. That doesn't mean the DANCO goes away. Same thing with an HRO, that could be dismissed, but there might still be a DANCO in place. And same thing with the DANCO. Even if the criminal court dismisses that order, there could still be a separate order for protection or harassment restraining order. So just because one gets dismissed, that doesn't automatically mean that contact is allowed. You have to make sure there's no other order in place. And for a DANCO, these cannot be modified by the family court. So for an order for protection, if there need to be modifications for that because of a subsequent family court case like custody or a divorce, and the court wants to add in provisions for communication about the children or for parenting time exchanges, it's pretty easy in most cases for the family court to issue an amended order for protection to allow for that type of contact. The family court cannot do that for a DANCO because it's not a family court order, it's a criminal court order. And the DANCO is also not under the control of the petitioner the same way that an OFP or HRO is. If the petitioner wants to modify their OFP or their HRO, they can file a motion and ask to do that. And usually the court will do what the petitioner is asking. If they're asking for exceptions to the no contact provisions for purposes of, parenting time or communication about children or something like that. But the criminal court does not have to modify a DANCO when the victim asks. It is up to the prosecutor whether to ask for that modification, and then up to the judge whether to grant it. And so it's a lot harder to modify those. I have seen it happen in family court cases sometimes where both parties do file a request into the criminal case or get in touch with the prosecutor and ask them to file a request. And so it can happen where the criminal court can be asked to modify the DANCO, but it's just a longer process than modifying an OFP or an HRO. So those are the main differences between these types of orders. I put my contact information here as well as Standpoint's action line. So if you have questions about these that we don't end up having time to get to today, or if you have questions that come up later, you can always feel free to call our action line anytime. We answer that from 9 to 4, Monday through Friday. And you can always leave a voicemail if someone's not available to answer. And then I've also put my direct email address there as well.
That is awesome. Thank you so, so much, Sammy. A couple of questions that popped in, so we'll make sure to go through at the end. But that was really interesting, especially because there are three different types, and I think sometimes people just think, okay, I need to get a protection order, but they don't necessarily understand where to go first or which one they would qualify for. So I'm glad that you kind of laid that out for us. That is huge. So thank you again. We are going to have any questions. Please make sure to put them in the chat. We are streaming on different services, so we have questions coming in all over. I don't want to miss your question. Have those put in there. We are going to move on to our next presenter, and our next presenter is Sarah from the Red River Children's Advocacy Center. And Sarah, if you want to go ahead, introduce yourself and take it away.
Sure. I am the executive director at the Red River Children's Advocacy Center here in Fargo, which is right on the border of Moorhead and Fargo. And so we do serve a lot of counties in Minnesota as well. We serve a total of 63 counties between North Dakota and Minnesota. So just to kind of give a little background on that as to where our services can support. I'm going to share my screen maybe. Okay, there we go. Hopefully you can see.
Yep, we can see you. We're good to go.
Okay. Okay. So you guys are seeing the one with the states, right?
Yes,
no?
Yeah, we can
Okay.
see that. Yeah.
Just making sure.
No worries.
Okay, so we're a nonprofit in the area that helps children and law enforcement and social services conduct interviews with the children. So we're a little bit different than some of the other legal services around. But what we do provide to these children is that multidisciplinary approach and the family. And so we really try to wrap all of the services around for the families to make sure that they're not having to be bounced back and forth and all around to find the information that they need. The multidisciplinary approach that we have is law enforcement or social services will connect a case to us and ask us to conduct the forensic interview with the child to help it be not so traumatizing. One, a child will tell their story between 8 and 10 times without the multidisciplinary approach. And so when they come to our center, we have them do it one time in a room that's recorded with all of those team members here in another room watching. It's, like I said, recorded for support in testifying and prosecuting of the perpetrators. So we really are that kind of in-between service that does help families get in contact with the services. So we don't provide or assist with getting and securing no contact orders. In North Dakota, the no contact order has to be court ordered by a judge. And so we just help them get through possible testifying. We have little fake court, I don't know what you call them, displays where it has the chairs and where the child would be sitting and things like that to help them get through and get used to what they would see in a courtroom when they have to testify potentially, as well as the family member or the caregiver who is bringing them. However, the caregiver may be the person who was the perpetrator and they might have a no contact order from that parent that we have to be aware of when they do come into our center. And then when we do have further contact with the people who do have custody of the child, we may have to know all of those things from that law enforcement team to make sure that if they disclose that they're speaking to their mother again, who is that no contact order, we report that to law enforcement and make sure that it's being upheld by a foster home or what may be. So we will do that as well and provide feedback to the team as we hear it. Our advocates are constantly in communication with families, so they may hear some of that information and or our mental health therapists. So we also do mental health therapy here on site via telehealth or in person. And sometimes we do hear that the child or the family member is seeing somebody who was on that no contact order, but the child may not know that. And so there may be situations that we need to interject ourselves and social services and law enforcement in to make sure that we are keeping that child as safe as possible, and as well as the caregiver as safe as possible. So we do provide resources in our area to other nonprofits. We have very large family packets that we put together that are very specific to each individual and each case's situation. So we don't give the same information or referral information to other places from one family that we do to the next. So we, like I mentioned before, we do provide court prep for children, and we also provide it for the caregiver who is bringing the child so that they can help the child to prepare for that as well. What else could I say? We also do provide expert testimony to cases. So Dr. Schimmelfittig here, she is a psychologist, and she has been contracted by several entities in North Dakota and Minnesota to testify as an expert witness to these cases for these children, to just ensure that their rights are being heard, that these types of cases that come through, these are the effects that could happen, the long-term, short-term, and so on. And she does a really great job on that as well. And the therapists during their therapy sessions will use that little diagram I was talking about, the actual doll type house with the chairs and everything, and they will practice with the child and about telling the truth and how they can get through that entire session without struggling or being as stressed out as they probably would be as being children on the stand. But yeah, that's kind of what I have. We don't actually, like I said, provide or help families get the court order, but we do have all of our law enforcement, social service friends that will be part of our team, and we're in constant communication with, that we will make sure that that gets done if it's needed.
Thank you so much, Sarah. You know, I think one of the main reasons why I wanted to have you on today is because a lot of people, they think when they are in, sometimes you're scared and you're in that domestic situation and you don't necessarily realize that not only do you need a protective order, but your children do too. And not only is your voice being heard, but your children's voice is just as important. And they need sometimes something special just for them to make sure that they are getting their voice heard and that it's going to be the truth and that it's going to be in a secure environment where they feel safe. So when I met with you and you told me about the Red River Children's Advocacy Group, I thought this is an important piece that I hope many organizations and community organizations know. It's a piece to the puzzle that is sometimes missing. And you guys do an amazing job of being able to help out when it comes to protective orders, to have somebody testify and let that child's voice be heard. It's an amazing organization. And we do have some questions for you. We will put those in at the end, but I just appreciate you coming in because a lot of people need to know that you guys are out there and that you do serve both sides of the river. So that's huge for all of us, you know? So thank you. Thank you very much. All righty. We are going to move on to our next presenter, and our next presenter is Kim Anderson Mohn, and she is from Someplace Safe. And I'm going to go ahead and share my screen so I can assist here. Give me one moment. Do-do-do-do. All right, can everybody see my screen okay? Yeah, perfect. All right, go ahead, take it away, Kim.
All right, thanks. As was stated, my name is Kim Anderson Moon. I am an advocate with Someplace Safe, and I have been with Someplace Safe for 18 years. You can go ahead and next slide, please. Someplace Safe was founded in 1979 as the Region 4 Council on Domestic Violence and had its start as a domestic violence shelter for women and children. Next slide. Since that time, Someplace Safe services have expanded. They now include 11 advocacy offices in 9 counties in West Central Minnesota, 5 parenting time centers, and 3 thrift stores. Next slide. Advocacy services include a crisis hotline, which is staffed 24/7 by trained Someplace Safe advocates. We also have a chat line and a text line. All of Someplace Safe's advocates are trained to provide domestic violence, sexual assault, sexual exploitation and trafficking, and general crimes such as harassment, burglary, arson, advocacy services. In addition to the general advocacy services, Someplace Safe has advocates that specialize in youth advocacy, sexual exploitation and trafficking, labor trafficking, and domestic homicide. Advocates receive specific training in assisting clients with and writing orders for protection and harassment restraining orders for the clients that we work with. If someone is asking for assistance with a restraining order, we can meet with them either in person or by phone to assess what their needs are, what it is that they're looking for, help to explain what each of the difference between each of the orders is, and to help them to determine if one or the other is right for them, and go from there with them. All of Someplace Safe services are client-led, so advocates assist in accordance with the client's needs and wishes. So even though we may say that somebody doesn't qualify for an order for protection as an example, but that's what they're insistent on doing, then we will assist them with that order for protection. Someplace Safe advocates are not attorneys, so we cannot speak for or on behalf of clients, but each Someplace Safe advocate assists with dozens or even hundreds of restraining orders each year. Excuse me. Advocates are able to clearly explain the restraining orders, the differences between them, the differences between an OFP, an HRO, and a DANCO, and the relief that can be requested in each. We can assist clients by writing the restraining order for them, which is very overwhelming for someone who was just handed a packet of paperwork. Someplace Safe advocates also can court prep with clients if there is a hearing and attend those hearings with the clients, either via Zoom or in person. Next slide. Someplace Safe also provides parenting time services through the 5 parenting time centers. The services that can be provided are services that can be asked for in an order for protection. If the petitioner is asking for supervised parenting time center or safe exchanges, so they can be court ordered in that order for protection. All right, and next slide. We're just cruising through this today. Someplace Safe also has 3 community thrift stores, and that can help with the advocates at Someplace, or the clients at Someplace Safe provide services to. We're able to provide the clients with vouchers for clothing or household items or what they may need in setting up a new household. And I really rushed through that, but that's what I have for today.
That's okay. Sorry, I was trying to find my unmute button. No, thank you. Thank you so much, Kim. One thing that I think about is when I first started here, they told me about Someplace Safe. And I was just like, I'm not exactly sure all the different services. And so I'd call out to one office and then I realized, oh, there's another office. And I was like, oh, there's another office. You guys have offices everywhere. You are able to provide services for, multiple different entities, families, children. So I love that. I've had to call Someplace Safe just to be able to get some more information. And every time I feel like I have new questions. So it's really, really a good thing that we're able to have you on so that people can see that what the services are that you provide and be able to get that contact. So thank you so much for being able to provide that information. One thing I also wanted to do is I wanted to, and I'm going to put it in the chat. I had some links for you guys. So I'll throw it in the chat, so if you want to copy them, you definitely can. Every time we have one of our legal tables, I like to always make sure that we go to Law Help. Oh, now it says that I can't share everything, so let me take out some of these. Oh, it's a learning lesson. Oh, I can't share all those either. So, okay, we'll do it a little bit at a time. How about that? Maybe not. Oh, great. Sorry. Okay, well, we'll share it a little bit at a time because it wouldn't allow me to share that before. But anyway, I always want to make sure that you guys know where documents are located so that everybody has an opportunity to be able to get to the documents. So I had our person from Legal Services State Support just be able to send me some important links that you guys should know and you should have in your back pocket just in case you do have a client that has some domestic violence or protective order type needs. So please feel free to go into the chat, copy some of the links, and I'm putting them in there one at a time. I do apologize, but it was acting kind of funny. But feel free to share the links. If you're looking online when we do our YouTube channel, the links will be listed below. So just make sure to look below when you're doing that. A couple of questions that I had as I was listening to the presentation today. The first thing I wanted to go to Sammy. And I heard that during the presentation, you talked about, if someone has an ex parte hearing, if somebody has an ex parte hearing, for some of the people that are not exactly sure what an ex parte hearing is, can you give us a little bit of detail or exactly what that is or what that means so that they know, what they're supposed to do?
Yeah, so when a petitioner files an order for protection, it goes to whoever the signing judge is that day, and the judge reviews the petition. And the question that they're thinking as they review it is, if everything in this petition is true, is there an immediate danger of continued domestic abuse? And if there is that immediate danger, then the judge can issue an ex parte order, which means an order before the other side has a chance to be heard. Usually courts don't like issuing orders before both parties have a chance to be heard, so that's why they have to have that finding that there is an immediate danger to justify that. So if that ex parte order is issued, sometimes a hearing is automatically required and sometimes it's not. It depends on what relief is being requested in the petition. If things like temporary custody or child support, spousal support are requested, that does require a hearing. If it's just asking for a no contact order, that does not require a hearing. So the judge will determine based on the type of relief if they are required to automatically schedule a hearing or not. If they don't have to automatically schedule a hearing, the respondent still has a chance to request one. They have to do that within 5 days of being served with the ex parte order for protection. And so if they make that request, the court will schedule a hearing. If the judge reviews the petition and they think, this does allege domestic abuse, but I'm not seeing that immediate danger, then they might not issue the ex parte order, but they can still schedule a hearing to determine if an order for protection should be issued after both parties have the opportunity to be heard. One thing that I like to always remind people about that is not every petitioner wants there to be a hearing scheduled if their ex parte order isn't granted, because that's a safety concern. They're worried about retaliation when the respondent finds out. There is a box to check on the petition to address that concern. It says it's something along the lines of if my ex parte order for protection is not granted, and then there are check boxes for I want a hearing or I do not want a hearing. So if that's a safety concern, they can say they don't want a hearing. That means they won't get an order for protection, but it also means the respondent won't find out that they filed one if no ex parte order is issued.
That's good to know. And thank you for that because I wasn't exactly sure if everyone kind of knew what that ex parte hearing was all about. So that's perfect. We are going to move to a question for Sarah. Um, so you did talk about people sometimes need to be court ordered for the children to have a testimony. But how about if there is, a suspicion from a parent that somebody is doing something to their child and they want their child to be able to speak in a free environment? How can somebody come to you outside of a court order? And if so, how are people referred to your agency?
Good question. I didn't go over how people are referred.
That's okay.
So the cases that come to us are already being investigated. So law enforcement and social services refer our cases to us or the families to us. We cannot take any kind of child or family on their own coming to us or referred by any other person. So only law enforcement and social services. Sometimes prosecutors will push for this for the investigation and make sure law enforcement or social services do bring the child and family through for a forensic interview. But the forensic interview is our primary service. And that's, like I said, just provided a legally sound disclosure potentially or non-disclosure to law enforcement and social services to aid in their investigation. And then that advocacy that comes afterwards or during that time for the child and family and those resources given out. But then when they are through our services or get connected with us, we don't just shoo them out the door or leave them. We do try to help them through any processes or anything that they may be coming up against. If they say that they do have to testify, or if they say that their child might have to testify, we try to prepare them as much as possible here with exercising and explaining and showing that prop, like I mentioned, the courthouse room setup. So that's really where we come in, is the support piece behind that or that expert testimony. We do have to be subpoenaed for that. We get subpoenas probably every single day at least. And so providing the expert testimony, depending on, we can't give any records out to anybody. Or, we don't give permission for anybody to be able to get that information.
Perfect. No, that's really good because I don't want to give anybody the idea that they can just walk in. I want to make sure that they know how to get to you. Oops, very, very sorry. I want to make sure that people understand how to get to you. Sorry, I always have like 15 different things that start dinging. My apologies. Okay. My next question goes over to Kim. Do the advocates that you have, do they come to the court? Are they able to testify if they're going to court with you? Or is
No.
it just it's just regular services? How does that work?
We can attend court with order for protection hearing, harassment restraining order hearings. We can attend them with the client that we're working with, but we do not say anything because we're not attorneys. So we're not representing those people. We're there as support people for them. We can help them to prepare for the court hearings, tell them what to expect, do diagrams of the layout of the courtroom if it's in person, which most of ours are still via Zoom. But no, we cannot be subpoenaed because in Minnesota as advocates, if domestic violence advocates have 80 hours of training, they have confidentiality. And as sexual assault advocates with 40 hours of sexual assault training, then the advocates have privilege so that we can't be subpoenaed to testify, and our records can't be subpoenaed.
That's good to know that there is that confidentiality piece in there. Sometimes people, I mean, not sometimes, people get scared. And it's really good to know that they can come to you and you're somebody that they trust. Um, a question did pop up in the chat. Want to make sure that I respond to that. And I believe this is for the Red River Advocacy. Are services from Red River Advocacy Center only for North Dakota residents?
Nope. We don't charge anything for our services, and we don't bill for any of our services. So all of our services are free, mental health, forensic interviews, advocacy. Um, so we serve 63 counties because of that. We have 3 locations. We have our Fargo location, our Grand Forks location, and a little tiny pop-up site in Devil's Lake. And so all of those cases can drive to those locations versus coming all the way to Fargo where we first originated from. So we have people at those sites that can help with the investigation. Law enforcement can just go there with the families and they don't have to drive 3 hours to get our services or to get the forensic interview in for cases.
No, that's good. Thank you so much. I just wanted to make sure I didn't miss that question that popped in. And while we still have you on there, Sarah, do you have a social worker that is on site so that they're able to get resources after they meet with you, just in case, additional resources?
We don't call them social or caseworkers. There are advocates. They do have their masters in social work. And so they give all of the community's resources because we are limited to what we can do by law with these investigations. Aside from our mental health clinic, we can do what we need to there with all of their ethics and all of their requirements. But because of the limited ability for us to take cases on, all of our cases come straight from those forensic interviews, and then our advocate will pick that is a part of that case from the moment they walk in the door for potentially 2-3 months, constantly communicating on the phone, providing resources. If they need a vehicle, we ask Fix It Forward, which is another nonprofit. We really do try to get them everything they need, housing resources, you name it, and gift cards for gas, gift cards for food if they need food. We provide them with clothing, hygiene items, all of those types of things. If you name it, we more than likely will help find a resource for it. If it's not our own, we will get them hooked up with another organization in the community, very similar to what a caseworker would do, check-ins constantly as well. But it's on their on the caregiver's schedule. So if they want to stop communicating with us at any time, obviously they can. Some will refuse advocacy services right away, but then when things start getting going and the case starts to go further and further, they end up calling back to our advocate and asking, okay, can you please help me navigate this system? It's very complex and complicated, and there are a lot of things that I need help with. And our advocates can do that.
That's perfect. That's really good to know because sometimes you'll run into an organization and they're like, hey, this is the service. That's it. I can't help you any further. So it's amazing to know that you still will be able to continue on that process. That builds that rapport, which is huge. And lots of people definitely need that. So thank you for that. So there was a question for Sammy. And so sometimes you see on social media that people are being bullied, people are being harassed. Um, I'm not exactly sure what people do when people are being stalked or harassed online. Is there a type of restraining order, protective order of some sort that pertains to that? Or, how do people even go about being helped when those situations happen?
Yeah, that's a great question. There's not a specific type of protective order for online stalking or harassment, but sometimes that behavior is going to fall under the definitions of harassment. So that person might be able to qualify for a harassment restraining order. Um, Especially if there's any direct contact from the person doing the bullying or harassment to the victim. That can fall into the definition of repeated unwanted contact that's having a substantial adverse effect on that person's safety, security, or privacy. So that might qualify them for a harassment restraining order. Um, it gets a little more complicated if the contact isn't directly to the victim. So sometimes there are cases where someone is posting about someone else on their Facebook status and it's causing an adverse impact on that person because other people are believing this or asking them about it. Or someone might be, just posting information about that person. That technically can fall into the definition of harassment as well. There are cases from the Minnesota Court of Appeals that say that direct communication is not necessarily required for harassment. You just have to show that there have been these repeated incidents and that it's having an adverse effect on the victim's safety, security, or privacy. I think without the direct communication piece, it might be more difficult to convince a judge that it's harassment, even though we have that Court of Appeals precedent. A lot of it is non-precedential cases, which are persuasive authority, but they don't technically have to be followed if the district court judge thinks this wasn't well reasoned. So those cases do get more complicated. Another thing that can complicate a case like that is if the cyber contact is being done anonymously, it can be really hard to prove that it's actually this person making that contact. I've seen cases like that where the victim knows who it is. It's pretty clear just based on their past interactions in the context of these anonymous posts, like who's doing it. But it's hard to prove that to a judge to the level that you need to get a harassment restraining order. So that can definitely complicate things. Some things I've done in situations like that is get I've done subpoenas for phone records before. If the messages are coming from like an anonymous phone number or phone calls from an anonymous number, I've had some success doing a subpoena for phone records to prove this number is registered to this person. I think it's a lot harder on social media because these are really large companies with um, some hesitance sometimes to respond to a subpoena like that. So I think it gets a lot more complicated, and that's where um, you'll probably want to reach out to somewhere that has expertise in those types of cases. There are a lot of resources for addressing like cyber stalking and cyberbullying and things like that. There's some organizations doing great work on that. So I would generally recommend if that situation is coming up where it's going to be really hard to prove because it's anonymous contact, getting in touch with one of those organizations and seeing what kind of resources they might have for helping you prove it to a judge.
No, that's perfect because we do get that question sometime. They want to know how they can be helped because that does definitely affect them, on a daily basis. And while I still have you on, so I've gotten the question before where a person is not sure if their protective order is still in place. Maybe they've mismanaged their paperwork, or even it's the person that the restraining order or the protective order is on. They're like, well, I don't know if I still have a Danko, or I don't know. Is there a place that you will refer people to, or is there a site that you use, or is there how can you help somebody in that instance where they're not exactly sure if that's on? Because sometimes people want to extend that, if stuff is still going on or if it's still a threat.
Yeah, yeah, that's a really good question, and that does come up. So generally, orders for protection are not publicly accessible, which does make it harder to verify if it's still in place. So if somebody's going to Minnesota court records online and trying to search for their order for protection, they're not going to find it there. Some attorneys have MGA access, which is broader than the public access. And so some attorneys with that access, it's mostly government and legal aid. So some attorneys might be able to look up an order for protection and pull up the most recent order and let someone know if it's still in effect. That's something I can as an attorney at Standpoint, I have MGA access. So if somebody wants to call our action line, and try to have us help figure out if there's an order for protection still in place. I can do that. Um, Otherwise, I think that if they go to the courthouse and request the records, since they are a party to the case, they should be able to get the records even though they're not publicly accessible. It's just going to take that extra step of going to the courthouse and requesting the records. They won't be able to get them online.
And if
And
I can just add to that,
Yeah.
there are public terminals at every courthouse, and there's much more information that you can access from those public terminals than you can from like the public sites that everyone can access. So as advocates, we can, or individuals can go up and access those court terminals, and you can look up like order for protection cases or whatever. You can search under criminal or civil or family and probate cases. And just searching under civil, under either the petitioner or the respondent's name, you'll be able to pull up that order for protection, and there's hyperlinks there. So you can click on and actually see the petition for the order for protection, the ex parte order for protection, or if there was a restraining order granted after a hearing. All of those things would be there, so somebody could actually look it up themselves. And if they want a copy of that current order to be able to see the expiration and stuff, they can have court admin print those copies out for them.
That's really good. I think one time I had somebody that had asked me, and I was like, gosh, I wonder if the local police department, if they can just go into the police department and if they can pull it up. So it's, it's good to know where people are able to go to be able to find and access that information. And then also, they are able to come into legal aid offices, if they have questions, they can always fill out intake forms. We can assess them as well. Let me see. Was there another? Oh, and then Kim, we do have one more question for you. And then we're going to probably wrap up today. Are there any charges for your services at Someplace Safe?
No, and I should have stated that. Someplace Safe is a nonprofit. All of our services are completely free to anyone who comes in. And our confidentiality, as I stated before, is like top notch, where we can't share anything about anyone that we've talked to without a very specific signed release of information from that person about who we're allowed to talk to and specifically what information we're allowed to share. And sometimes we will get like opposing parties seeking services. And we have the advantage of having 11 offices. So if somebody identifies as a victim, but they're a conflict for our office because we've provided services to the other party, we can send out an email to all of the other advocates and ask if someone is available to take a conflict to make sure that anyone who is identifying as a victim of a crime is receiving the services that they're seeking.
Okay. That's good. That's really good because I think sometimes people think, gosh, I don't have a lot of money. I'm low income. What do? I want to be able to get these services, but I can't afford an attorney. I can't. So it's really great that they know that they can come to your offices to be able to do that. Okay. So with that, if there's any last questions, can you throw it in the chat really quick? We want to make sure that we've answered everybody's question today. We'll leave one more minute to see open for questions. All right, and then I'm going to go ahead and share my screen while we're here, while we're waiting for that, just in case anybody had any questions about the services that we do have at Legal Services in Northwest Minnesota. Just want to make sure you guys have that information. I also want to make sure that If you would like to be a presenter, please feel free to give us a call. We have the legal table once a month, and it's always on the third Tuesday of every month. We have a different topic where we cover civil legal issues. Or if you would like a presentation from one of our attorneys to your organization, staff or presentations, or community presentations, feel free to let us know and we can get that information out to you as well. You can use the QR code to book an appointment with me, either virtually or in person. And then we also have everybody's information. I hope I have everybody's information in there correct. If not, please put it in the chat. But we want to give a huge thank you to all of our presenters today. Thank you for the valuable information. Thank you to let us know how we're able to refer clients to you and how we're able to come in to get our services. If you do have any questions, please feel free to reach out to our presenters. Feel free to reach out to their offices or to me. And if we have no other questions, we will go ahead, and we're just a couple minutes early today, which is always a great thing. Thank you. Last thing that we have, I just wanted to make sure our next topic is going to be dun, 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 dun. I'll stop sharing so that I can let you guys know. Hold on one second.
If you were sharing a minute ago, we could not see it.
Oh, okay. Well, that's good. I thought that I was sharing, so sorry about that. Let me go ahead and our next topic is going to be in November. And for our November series, we will be talking about dun 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 dun. It'll be about housing. These will be about alternative housing organizations. So we have some really, really great presenters. I think we have 5 presenters. So that'll be a huge one for November. So make sure to register for that one. And then I will make sure now to, here we go, share everybody's information at the end here. Okay. Can everybody see my screen now? Perfect. So we want to thank Someplace Safe, Standpoint, and Red River Children's Advocacy Center for being on today. If you have any questions, please reach out. Thank you guys so much for attending, and you guys have a wonderful rest of day.